Stephanie Dobson is back with us for another episode of Healthy Thriving Family After Divorce. Stephanie is a lawyer, mediator, and online educator with Hankett Divorce Law and Mediation offices in Edmonton and here in Lloydminster. Stephanie, thank you for joining me.
Thanks again for having me, Stacey.
Today, we're going to be talking about relocation. When there's separation and divorce involved, this could be a very contentious issue. So, first of all, if a parent wants to move after a divorce or a separation happens, where do they even start?
So the Divorce Act is the legislation for married parents, and the Children's Law Act in Saskatchewan is the legislation for unmarried parents. So that's where we start out, and that's those two pieces of legislation tell us what needs to be done if you wanted to move. So the first thing that we need to do is to figure out whether that move is going to be called a change of residence or a relocation. So there are two different types of moves that are addressed in the legislation. So a change of residence is technically it's very broad. It's basically a change of where you're living, irrespective of how far the move is from your current residence. It's just a change from one residence to another. A relocation is defined much more specifically. It's certainly a change of residence, but it goes one step further. So it's when they're likely to have a significant impact on the child's relationship with the left behind parent. So that's what we define as a relocation. So it doesn't necessarily give a certain geographic parameter for that change. It just depends on the existing arrangement. So for example, for one family, a change half an hour down the road might significantly impact the relationship, but because in that situation, the parents are 50-50 parenting. And in others, a 250-kilometer move may not actually impact the relationship much because the other parent only sees the kids on school holidays. So it really depends on the situation.
So, once it's determined that there is going to be a change of location, then Stephanie, what happens next?
So if you're a parent who has parenting time or decision-making responsibility, you're required to give a notice of the move, whether it's that change of residence or the relocation. So who do you have to give that notice to? You have to give notice to someone else, so another parent who has either parenting time, decision-making responsibilities, or what's called contact time with a child. So anyone who basically sees the child. So there's different in the type of notice that you need to give. So again, we go to the change of residence and relocation. So for the change of residence, it has to be prior to the move. It needs to be in writing, and it needs to give the date of the move, the new address, and the new contact information. So for the relocation, it has to provide all that same stuff, but there's additional criteria. So the notice actually needs to be provided 60 days ahead of the relocation. And the relocating parent actually needs to also include their proposal for how parenting time and decision-making responsibilities will look after the relocation. And the idea with this is the courts are trying to sort of preempt any disputes that might arise as it relates to the relocation.
But what if somebody does want to object to the move?
So there's differences whether it's change of residence or relocation. So for change of residence, there's no formal objection process. It's more notification. So the parent who's moving is notifying the other parent of that change of residence, and they're not asking permission, they're just notifying. When the move is a relocation, there is a more formal objection process. So the objection or a court application needs to be received by the relocating parent within 30 days of that relocation notice. Then if that happens, if that objection notice is provided, then the relocation will not be able to occur unless there's a court order or, of course, agreement between the parents.
And if they can't settle this themselves, Stephanie, then what is the next step?
So it's always my recommendation to get professional assistance. So whether that's a lawyer or a mediator, if you can't figure it out between yourselves. So certainly in Alberta and Saskatchewan, there are requirements for out-of-court processes like the collaborative process or mediation to try before you end up in court. But ultimately, as you said at the beginning of this, Stacey, there's lots of times where this is a really contentious issue, and you try mediation or the collaborative process and that fails, and you end up having to go to court.
All right, Stephanie. Well, thank you so much. Again, this is one of those things that can either go really smoothly or there's a lot of steps that end up having to happen. So
It's
thanks for
very
clearing
true.
that up for us, and we will chat with you again next week.
Thanks, Stacey.